Hello, everybody. Good afternoon, and welcome to the next of our series. I'm Lottie, founder of the Jury Society. We are a community and concierge that explores what wealth means to modern women by providing them with the financial and legal knowledge to take control of their wealth and well-being with confidence. So this afternoon, I'm really excited to welcome Rachel and Sarah from the Wills and Estates and Tax Planning team at Thomson Snell and Passmore to talk all about deeds of variation, what they are, and how they're to be used. So we're going to be looking at what exactly they are, how it makes financial sense to you, and the family and legal considerations that determine whether they are the right move. So let's get started. Let's go over to the ladies. Hello both, how are you?
Hello. Good. Thank you for having us very much.
So welcome, and I'm super interested to learn more about these interesting little tools that you have in your toolkit. So let's kick it off by both of you sharing who you are and what you do.
Okay, so I'm Rachel Mayston. I'm a senior associate, as Lottie said, in the Wills, Estate and Tax Planning team, and my advice generally covers all things related to succession and the transfer of wealth. So I advise individuals and trustees on everything from the preparation of wills and trusts to family investment companies, landed estates and heritage assets.
And I'm Sarah Nettleship. I'm a partner in the Wills, Estates and Tax Planning team. And I, like Rachel, advise on all aspects of estate planning. I have a particular focus on business owners, but I do cover all aspects. And I, in particular, love advising on deeds of variation. They're one of my favourite topics. So I'm really happy to be here today to talk about them.
Well, I'm thrilled that you're thrilled about this topic. You better to talk about it. So I guess quite a few people might actually never have heard of one of these before. It isn't something that comes up in your day-to-day discussions or dinner table chats. How would you describe what a deed of variation is to somebody who's, never heard of it before?
Yeah, well, they do come up on our dinner table chats, but yeah, regular people. I think the simplest way of describing them actually is that when someone makes a deed of variation, they're making a gift with special tax consequences. So the deed of variation is a legal document that allows a beneficiary to redirect their inheritance. And if certain criteria are met and it's done within 2 years of death, then the redirection is read back. So it's treated as if the person who died made that redirection. And that's a very useful tax planning tool. Usually, if you make a gift and then you die within 7 years of making the gift, that gift is brought back into account for inheritance tax purposes. So this deed of variation prevents that from happening.
How fascinating. Why would everybody not have one of these?
Right.
And I guess, you mentioned that this is on the beneficiaries as well to actually take charge of. So how often do you find that a beneficiary will come to you within that 2-year window? Now, this is quite a specific time period as well. And I guess it's quite a short time period for some people if they're going through a grieving process and, perhaps it's quite a complicated estate that they're dealing with. But how often do you find that people miss that window and they come to you after it's closed?
I would say it really varies. If a beneficiary has been involved in the estate process, so perhaps they might be an executor themselves, or they've just been closely involved with the probate solicitor running the estate, that probate solicitor has probably advised them about the possibility of a deed of variation. A good probate solicitor always will. And so then they usually come with it to us well within the 2-year window. But often it can also just come up as part of a general estate planning review. It's a question we often ask you: have you inherited in the last 2 years? And sometimes people will say, yes, I have. And sometimes people will say, oh, it was 2.5 years ago that my mum died, or it was 3 years ago. And at that point, there's nothing we can do. It's a really strict 2-year deadline. But if they happen to be within that window, even if it's just within, we can provide a solution at that point.
Yeah, I guess. And again, this is why we do these kinds of conversation. It's about awareness and, it's the unknown unknowns. But what might be some of the common reasons someone would want to vary an inheritance they've already received? Why would you want to give that back? Yeah. Or pass it on?
There are a few reasons, really. I think the first is, if someone simply feels they have enough, they're comfortable with what they have, they might have a taxable estate themselves, so they don't want to bring anything further into their estate to further inflate that inheritance tax position. And they simply know somebody else that needs it more. Perhaps they have a child who's looking to buy their first house, needs a house deposit, and so they would rather redirect their inheritance at that stage. So tax might not be the primary driver, but it's a happy consequence, really. Another reason might be fairness. So I have advised a family before where a mother decided to leave her estate equally between 3 of the 4 siblings and excluded the 4th sibling entirely due to being estranged. And obviously it does happen, and that was her choice. But the 3 siblings, despite really not having much of a relationship with the brother, just felt that was unfair and wanted to come together to make sure that overall they each received 25%. But by far and away, the most common driver is the tax planning aspect. I mean, as Rachel said, it's a gift with tax consequences. So you don't have to use a deed of variation just because you've inherited. You can just give that inheritance away, but the tax consequences within a deed of variation are really quite unique in the estate planning field. As Rachel said, anything you give away is not on your 7-year clock, and so you don't have to worry about dying within the next 7 years. You know that it's immediately gone. Another sort of great tax planning option available within a deed of variation is actually using a discretionary trust. So redirecting your inheritance into a trust rather than giving it away outright actually means you can still benefit. You can still be a beneficiary of that trust. And in the real world, if you were to put money into a trust yourself, you can't benefit if you want it to be out of your estate for inheritance tax purposes. That simply just doesn't work, and you're limited to how much you can put in. Whereas under a deed of variation, if you were to set up a trust, you have a really unique opportunity to put far more into it and also be able to benefit from it yourself. It's important to remember that it is a gift with special tax consequences. It doesn't protect in other aspects. So if you've inherited and you are going through a divorce, putting assets into a trust or giving them away via a deed of variation is not going to help on your financial settlement. That will still likely to be taken into account. Equally, if you're on benefits and you want to redirect your inheritance because having too much capital in your estate means you can't carry on with your benefits, equally that's not going to work. The key of deed of variation is the tax consequences, not the sort of real world consequences, if that makes sense. But to come back to what your question actually was, by far and away, it's the tax planning aspect that drives a deed of variation, really, as well as a good degree of generosity.
Yeah, I think that's a really interesting point as well about being able to put it into a trust. I think that gives you so many more options and flexibility depending on what stage you are when you're receiving an inheritance. So that is a really interesting point that you have raised. But I guess, what does it mean in practice if the variation is treated as if the deceased made the gift and not the beneficiary? And why would that matter for inheritance tax purposes?
Well, so if I do some examples, I'll run through an example. So a simple example, which we've already touched on. Let's say I inherit £500,000 from my aunt. I don't need the money, but my daughter does. So like we said before, I can either make a gift, and then if I die within 7 years, that's brought back into account, that 500,000, and there will be inheritance tax payable because that gift exceeds my nil rate band. So my daughter would have an inheritance tax liability on that gift. The alternative is that I do a deed of variation. 500,000 goes to my daughter, but for inheritance tax purposes, it's treated as if my aunt left that gift in her will. So it doesn't matter when I die. It's nothing to do with my estate. The inheritance tax has been paid. If I die within 7 years, nothing gets brought back into account. So that's a simple example.
Yeah.
From a tax planning perspective, when we start getting trusts involved or things need to be more flexible, let's say this time I'm going to inherit £1 million from my aunt, and let's say that I already have concerns about my own inheritance tax exposure. So I'm concerned about the amount of tax that will be payable when I die already. And what I don't want is £1 million topping that up, which I might not spend. And it's just going to increase my inheritance tax liability on my death. I'm thinking that I might like to spend some, I might like to give some away, but most of it, I'm not sure what to do with yet. So what I can do is vary that £1 million into a discretionary trust. I could make me and my husband trustees. And then that £1 million is outside of my estate. If I die, it's not taken into account for inheritance tax purposes. We can make distributions from the trust to me or to my children as we see fit and spend it in that way. But we could also take it a step further, and I could borrow funds out of the trust. And if I borrow funds out of the trust, then not only is that £1 million not in my estate, but I've now also created a debt in my estate. And that reduces my inheritance tax liability further because my estate is less. And the funds, when I die, as I said, the value of my estate is reduced. And my children, when they take over the trusteeship, can then either repay, that they'll have to repay the trust, but they can either borrow funds back out the trust again, or they can take funds out and wind up the trust. They can make a decision at the time, depending on what their own situation is. So it can provide an onward tax planning vehicle.
Sexy stuff. Yeah. No, but again, it's the flexibility that this, you just think something like, oh, it's a deed of variation, but when you get into these, that is a really, really useful couple of case studies there. So yeah, thank you for bringing that to life.
And with the latter example, that's a key example as well, where professional advice is highly recommended because it can go quite wrong.
Yeah, obviously, clearly, because I think people as well, if they're like, I can do this, and then they get overexcited, and then it all just spirals, and then they have to pay more than they would have done if they had just listened to someone sensible in the outset. How about when people die without a will? If they've died intestate, can a deed of variation be used?
So yes, it can. So the key point is that you've inherited. It doesn't matter whether there was a will in place or not. And actually, an intestacy can be a time when actually you really should consider a deed of variation. So if you have perhaps a large estate and it's a first death, so somebody has died leaving a spouse and children. In that scenario, the spouse would inherit the personal chattels of the deceased, so furniture, jewellery, etc., and the first £322,000. That's a sort of a limit that changes. It's set by the statute. And then what's left is divided half to the spouse and half to children. And if what's been left to the children is more than the available nil rate band, then tax will be payable. Now, that's not normally how someone would choose to structure their will. In most cases, you would structure your will so that the spouse exemption applies on the first death. So either the spouse receives everything outright, or perhaps you would make use of a trust, but you would make sure it's a trust where the spouse exemption applies. So in that scenario, in that intestacy scenario, as long as the children are over 18 and of sound mind, they can vary their inheritance back to the surviving spouse so that the whole estate is spouse exempt. There's a few traps for the unwary in that scenario, but in general, it's a really good way to make sure that you're getting the spouse exemption by using that deed of variation there on an intestacy. It's also useful to know that if you've inherited something but you die yourself within 2 years of that inheritance, your executors or administrators can also vary your inheritance as well. So there are options there as well. So an intestacy is not the end of the world.
Well, it's for the person who died.
Well, we always say, lifetime planning is better. But a deed of variation can provide a solution there.
That's really good. Now, we all know human behaviour, not everybody always gets along, especially when it comes to families. who has to agree to the deed of variation, and what happens if one of the beneficiaries refuses?
Well, actually, it rarely happens, because only the person who, yes, people might be unhappy, but only the person whose entitlement is affected generally has to join in the deed. So people, especially with outright variations, people often beneficiaries work in silos. They don't always do things together. So if I inherit something, it's nothing to do with any of the other beneficiaries of the estate. I can vary it if I want to, and they don't have to agree to it. The only time where you definitely need someone to join in is if you're doing a variation which increases the inheritance tax, and then you need the executors to join in, and then you'll send a copy off to HMRC as well. That's also quite rare, because most people don't do a deed of variation to increase the inheritance tax. So actually, although people aren't always going to get along, and they might not like what somebody has inherited, they can't force anybody to do a deed of variation. Yeah, it's an own decision. So
yeah, okay, that's good to know. And you just touched on there situations where a deed of variation might increase the tax liability. Could you give us an example?
Absolutely. So deed of variations aren't actually automatically tax efficient. They simply produce a scenario where you've read back the tax consequences to the deceased. So an example would be if a spouse has received the whole estate, so the spouse exemption applies, and then that spouse decides to vary to other people, so another non-exempt beneficiary, so basically anyone other than a spouse or a charity. And if what they vary, again, is more than the nil rate band, then that will actually produce a tax liability. So in that scenario, the surviving spouse would be far better actually using a normal gift, so not using a deed of variation, using a normal gift to give some of that inheritance away and hope to live 7 years, so that they've not produced an immediate tax consequence.
Okay, that's a good point to note as well for everybody listening. Be aware. Let's talk about the actual process. So we've done a bit of the practice, but what about the process? What does it look like from the moment someone decides they want to vary their inheritance to the point where the deed is in place? Talk us through the journey.
Well, it's pretty straightforward, actually. So it's a quick explanation. So people will either come to us when they want to vary, they'll know that's an option, they come to us specifically, or it comes up as part of an estate planning meeting. But either way, we start with a discussion about the options that are available, the tax implications, and the onward administration that might arise. So we discuss everything, we agree on a course of action, and then we prepare the deed. It's as simple as that. Once the deed is prepared, we can then let anybody that needs it have copies so that the estate could be administered in accordance with the variation. Although sometimes variations are carried out after the estate is completely administered, and at which point all the distributions have already been made, so the original beneficiary will simply give away what it is they've redirected and deal with it themselves. But our part, the advice is the bit that takes the longest, really. And then once we've got a deed in place, it's just a matter of getting the asset to the new beneficiary.
So I was just wondering, with that 2-year window, is that 2 years from the date of death, or
2 years from the death of the person who's,
or is it from like the certified, when they get the death certificate? Is it?
No, it's from the actual death. Yeah, the date they actually died. So it comes around quite quickly, and especially with complicated estates, it can take quite a while before people have got to grips, as you said earlier. Not just with the grief, with it taking a while to gather what assets there actually are and the value.
Finding a will.
So that they can make a decision. They need all the information before they can make a decision. If they don't even know what the amount they're inheriting, they can't really get very far with that conversation. So
obviously we talked about the importance of getting proper advice. What is the common mistake people will make when attempting to do this DIY or without proper legal advice?
So missing the 2-year deadline has got to be one, but also ending up making a gift that doesn't achieve the tax consequences that they thought it would achieve. So there are some very strict rules within the legislation about deeds of variation, and if, for example, I think Rachel gave a scenario earlier where children had inherited and the spouse hadn't received anything. If the children were to vary to the spouse in order to get the spouse exemption, but there were some preordained steps which meant that the spouse would be giving it back to them, through some method or another, then that simply doesn't work for the purpose of the legislation. It would be void. So, but what they have done is made that gift. They've given their inheritance away to the surviving spouse, but due to those preordained steps, they're not going to get the beneficial tax consequences. So it's the worst of both worlds there, really. Not to mention that people really shouldn't be doing these things DIY. So please don't. Deeds in particular are legal documents and should be dealt with by qualified professionals.
Yeah, you don't know if you're opening up a sort of a tangle of additional consequences that you thought, and a lot of people do it with good intentions, but actually it can just end up being a massive headache, especially when you're going through grief or something like that. I think it's always good to do it properly from the outset if you can. Yeah. So, charitable giving, that's quite a nice thing that people do when they die, isn't it? What if this is included in a variation? Are there any tax implications on that? And if people didn't know that thing about the 10% threshold for reducing your IHT, maybe it's worth actually just starting on that. Can you give us a little overview on that, and then come to how the variation would work with charitable giving?
Yeah, well, this is actually one of my favourite variations to do because it's so nice. So, as the backstory, as Lottie said, if you leave or somebody leaves more than 10% of their estate to charity, then the inheritance tax rate that applies on the rest of the estate reduces from 40% to 36%. So the amount going to charity is exempt from inheritance tax anyway, and then the remainder receives that reduced inheritance tax rate of 36%. It doesn't sound like much, 4%, but on a large estate, actually, it's quite a lot. So where that comes in with deeds of variation is with this tricky little calculation that arises. So if in an estate, the person who died has left up to 4% of their estate to charity, that's all very well. But once it hits the 4%, a calculation comes in, which means that the other beneficiaries, the non-exempt beneficiaries, the non-charities, may as well increase that legacy to charity up to 10%. If they do so, then they receive the reduced inheritance tax rate of 36%. And the way the calculation works out is that if you go up to that 10%, the charity clearly gets more, HMRC get less, and the beneficiaries receive net the same. It's more or less the same. So it's an easy win for the charities. The beneficiaries don't get anything out of it, but HMRC get less and the charities get more. But again, it's a tricky calculation, and it needs to be done by professionals because it's not the general estate, it's a defined tax base that you use for that calculation. But yeah, and that's an example actually where beneficiaries do need to come together and work together, because if one person gets that idea, they won't generally want to leave, to redirect all of their estate to get to that 10%. They'll want to do it so that each beneficiary does a small equal amount to get them up to that 10%. So it's fair. So that's something where I guess you may have conflict if somebody doesn't want to deal with, doesn't want to do that charitable legacy just because they don't want to pay the fees or something like that. But generally, people quite like the idea.
Yeah, I love that. I'm game for that. Cool. More of that. Brilliant. Thank you. And thank you for the explanation. So They do require agreement from all affected beneficiaries, however. Is this correct? Yeah.
Objective beneficiaries, yeah.
Yeah. How do you manage those family dynamics when there is a disagreement, and who should benefit?
Well, I think Rachel mentioned earlier that it's only the person who has inherited that needs to vary. So it's not so much a case of consent. If there's a desired outcome that can only be achieved by everybody or a certain number of people varying their inheritances, then clearly you'd need agreement there. I think I mentioned my family where the three of the four siblings had inherited, and they wanted their brother to get 25%. So clearly they needed to come together there to make sure that each varied enough to achieve 25% each. But there's no actual onus on any of them to have done that. So it might have been that only one of them wanted to do it, and either had to give away more of their share so that brother got 25%, or sort of accepted that only their share would be shared between themselves and their brother. I think it's more a case of communication is key rather than consent, because actually anything you've inherited, you're entitled to do what you want with it, and if you're trying to achieve a certain tax advantage, then you've only got control over what you can vary. There's no onus on anyone else to agree with you or to join in doing the same thing.
Yeah, I guess one application I was just thinking could be if, there are works of art or a particular collection where it would hold more value if they were together. So say, there were two pots or something like that, and then the parent had left one to each of the child, but actually that's more than half the value of that as a collection, perhaps, and then they would actually need to work together to think, right, well, how do we manage this for impact?
Absolutely, and that could be quite a conflicted argument if they're sentimental, because you sometimes see these collections are sentimental as well as having a value. So it might not be as simple as, well, I'll take the paintings and you have the cash equivalent if everybody wants the paintings. So
yeah, exactly. Especially if it's like, family paintings and you've got everybody in the picture, it's like, well, then who has the picture? It's like you have to timeshare of the portraits or something. And this actually segues very nicely into blended families. They're pretty common, and it's one of the areas where deeds of variation probably come up quite often as well. When you've got more new children added into the family from different areas of the world, whatever, different bits. What makes those situations particularly complicated?
Well, I think the thing that makes them most complicated actually is the fact that you can't force anybody to make it, to change what they've received. So I had some clients, and the father who had died left everything to children from the previous marriage and left nothing to the surviving new spouse. Now she's entitled to make a claim on his estate for reasonable provision, and so you end up in a situation where there's negotiation going on, and actually the children were keen to put in a deed of variation in lieu of her not making a claim. Well, as Sarah said, that would make the deed of variation void. So you can end up in quite a tangle where they're trying to agree how things should be and trying to avoid going to court. Nobody can make anybody do anything. So, and if it goes the other way around, where a surviving spouse receives everything outright, and the first spouse to die relies on the fact that they will do the right thing and divide everything up fairly, they have no incentive to give it away or pop it in a life interest trust, because why would they? They're financially secure at that point. Any legal advisor is going to say, I'm not sure why you would, just keep it. So it is fraught with competing interests, and there's not always that much you can do. With blended families, it is far, far better to have the will set up properly, because it can leave people out in the cold, because the deed of variation in those situations can't always cover the scenario. If everybody gets along and somebody just says, oh, well, I feel sorry for my stepmom, I'm just going to give her something, then that's absolutely fine. But
life doesn't always happen like that.
No, it doesn't always happen, so, unfortunately.
No, but that's a really, really good point. And yeah, another reason why it's so important to try and prepare as much as possible in your lifetime planning, as you mentioned, Sarah, is so key to smoothing out things. I know a lot of people are like, oh, I'll be dead, it's not for me to sort out, but actually they're probably going to resent you a little bit if you do leave that little mess. So I think it's good to go out with nice impression from your loved ones. How would you advise clients who feel guilty about varying in inheritance, especially when they are redirecting away from an intended, intended wishes of the deceased?
I'm trying to think if many of my clients have ever felt guilty about it. I think in general, people are doing this because either they didn't agree with what was put in the will in the first place, or the situation's simply changed since it was made. And I often have sort of children coming to me saying that their parents are elderly, and what should they be thinking about in terms of estate planning. And I would obviously recommend coming to us for a conversation. The parent coming to us for a conversation, but often the children say, well, were their capacity is becoming a bit shaky, or they just don't have the appetite to redo their will or think about estate planning. And so I often say at that point, well, as we've said, the best thing you can do is a well-written will, but a good second is a deed of variation that they could consider afterwards. So sometimes children are even thinking about deed of variation, well before that inheritance is even on the cards, because they simply know that lifetime planning is not going to happen. But I don't think anyone should feel guilty about varying an inheritance either. If they've been left something outright, then they've been entrusted to do what's best with it and what they want with it, and they know what's best at that time, both for tax efficiency, but also in terms of their own redistribution of their wealth.
Yeah, that's a really good point. I guess for our final question, thank you, ladies. If there is anybody watching today or on the replay or anything like that, who is either inheriting or receiving an inheritance, or whose own estate needs to be taken into consideration, what would be the single most useful thing to understand about a deed of variation at the present moment?
The 2-year window.
Window. Think of that. Deed of variation.
Being aware it's an option, and being aware there's a 2-year limit. And actually, a week before the 2-year limit isn't great either. Thinking about it well in advance is helpful. And I think so the women that are thinking about the inheritance that they're leaving people, I think the most important thing is to make sure their will is done as well as possible, so that their beneficiaries don't need to do a deed of variation if they can help it. But knowing that it's an option, especially women, as I think we talked about at one of the events, Lottie, the sandwich generation of women, where they've got their kids coming up and they have their parents on top, knowing that they can get their will sorted for their children, but at the same time they have an option for when they inherit from their parents. I think knowing it's there, knowing the 2-year window, seek professional advice. I think that's the 3 points.
Super. Wow. Well, thank you so much. I love your enthusiasm for this topic as well. You are spot on. All of that was so interesting. I love the fact that you gave us those case studies as well. So huge thank you from me and from everybody who has been watching as well. If you do have any questions for Rachel or Sarah, feel free to reach out to them directly or come to me and I will connect you. But yeah, amazing. Thank you so much, ladies.
Thank you very much.
Thank you.
Thank you.